Breaking news that is absolutely exploding across every news network, every social media platform, and every legal office in America right now. In a move that virtually no one saw coming, the Supreme Court has just delivered a stunning 9-0 unanimous decision on firearm confiscation, and it's already shaking this country to its core in ways that are going to reverberate for years, possibly decades to come. When I tell you this decision has sent shockwaves through the legal system, through state governments, through federal agencies, and through millions of American households, I'm not exaggerating even slightly. This wasn't some narrow technical ruling that only affects a handful of cases in one jurisdiction. This wasn't the kind of split decision where the court divides 5-4 along predictable ideological lines and both sides can claim some kind of partial victory. No, this was a full-force, across-the-board, unanimous rejection of a major confiscation strategy that several states had been relying on as the foundation of their firearms enforcement policies. 9 justices, spanning the entire ideological spectrum of the court, looked at what these states were doing and said with one voice that it cannot stand, that it violates fundamental constitutional principles, and that it must stop immediately. The moment this ruling dropped, and I mean the very instant it was published, legal teams across the country went into crisis mode. State governments convened emergency meetings with their attorneys general trying to figure out what this means for their laws and their enforcement programs. Federal agencies started scrambling to understand how this decision affects their regulatory authority and their coordination with state-level enforcement. Gun rights organizations immediately began strategizing about how to use this precedent to challenge other laws they've been fighting. Gun control advocates went into damage control mode, trying to figure out how to salvage their policy goals in light of this constitutional roadblock. The message the court sent was loud, it was clear, and it was absolutely unmistakable. So what exactly did the Supreme Court strike down in this 9-0 decision? Why was every single justice, including those who have historically been more sympathetic to firearms regulations, united in rejecting what these states were doing? And perhaps most importantly for where this story goes next, what expansion of this ruling is now being aggressively pushed forward by lawmakers, legal advocates, and millions of Americans who see this as a once-in-a-generation opportunity to restore constitutional limits on government power? Stay with me, because we are watching constitutional history unfold in real time. To understand why the Supreme Court felt compelled to intervene with such a decisive and unanimous ruling, you need to see the legal chaos that had been building across the country over the past several years. Multiple states, particularly those with strong gun control political coalitions, had begun implementing confiscation tactics that were tied to increasingly ambiguous laws and administrative powers that gave government officials broad discretion to seize firearms from citizens. These weren't traditional criminal proceedings where someone was charged with a crime, given their day in court, and then potentially had their weapons forfeited as part of a criminal sentence. These were civil or administrative proceedings, often initiated based on subjective assessments of risk or danger, where firearms could be confiscated from people who had never been convicted of anything and in many cases had never even been charged with a crime. The legal framework supporting these confiscations varied from state to state, but the common thread was that they all claimed some kind of emergency or public safety justification that supposedly allowed the government to bypass or significantly weaken the normal constitutional protections that would apply. This patchwork of different confiscation schemes created a wave of lawsuits as affected gun owners challenged the constitutionality of having their property seized without what they argued was adequate due process. Cases started flooding into federal courts, and here's where the chaos really intensified. Lower courts across different circuits began issuing completely conflicting rulings on whether these confiscation tactics were constitutional. Some judges looked at the facts and said these programs violate fundamental rights and cannot be allowed to continue. Other judges looked at very similar programs and upheld them, reasoning that the government's interest in public safety justified the restrictions on traditional procedural protections. This circuit split, where different parts of the country were operating under completely different constitutional rules, created exactly the kind of legal uncertainty that typically forces the Supreme Court to intervene. The turning point came when one particular case, with facts that perfectly illustrated all the constitutional problems these confiscation schemes created, finally made its way up to the Supreme Court after lower courts had failed to provide any kind of consistent guidance on where the constitutional boundaries actually lie. The case involved gun owners who faced sudden confiscations without what any reasonable person would consider meaningful due process. Let me break down exactly what this 9-0 ruling says and why its meaning is so explosive for the future of firearms law in America. The Supreme Court ruled, in language that was direct and forceful, that firearm confiscation without strict due process protections and clear historical justification grounded in the nation's constitutional tradition cannot stand under the Second Amendment and the Due Process Clause of the 14th Amendment. The court made it crystal clear that the government cannot simply declare an emergency, point to public safety concerns, or invoke administrative convenience to justify taking firearms from citizens who have not been afforded the full protections that the Constitution guarantees. Now, the fact that this decision was unanimous is absolutely critical to understanding its significance and its power. When you see a 9-0 vote on a firearms case, on an issue that normally divides the court along ideological lines, that tells you something profound happened. It means that even the justices who have historically been more willing to uphold gun regulations, who have written opinions emphasizing the government's interest in reducing gun violence and regulating firearms for public safety, looked at what these states were doing and concluded it crossed a constitutional red line that they could not accept. The conservative justices who typically form the majority in Second Amendment cases were joined by their liberal colleagues in saying that there are limits to government power that cannot be transgressed, no matter how well-intentioned the policy goals might be. The court's opinion contained serious warnings about the dangers of allowing modern interpretations of emergency powers, administrative authority, or expansive public safety justifications to override fundamental constitutional rights that have been protected for centuries. The nationwide shockwaves from this decision hit within hours, creating immediate and dramatic consequences across the entire country. States that had built significant portions of their firearms enforcement strategy around the confiscation mechanisms the court just struck down were forced to halt their programs essentially overnight. Law enforcement agencies that had been executing confiscation orders under the authority of these now unconstitutional laws received urgent guidance from their legal departments to pause related enforcement actions pending further review. Judges presiding over ongoing confiscation cases in multiple jurisdictions across the country issued orders freezing proceedings until they could fully analyze what the Supreme Court's ruling meant for the cases before them. The shock of this decision rippled through the legal system because many states had quietly and systematically built large parts of their entire gun control enforcement infrastructure on the very legal foundation that the Supreme Court just demolished. These weren't peripheral programs affecting a handful of people. In some states, we're talking about confiscation mechanisms that had been used hundreds or even thousands of times, that had become routine parts of how those states approached firearms regulation, and that political leaders had championed as critical public safety tools. And in one unanimous decision, the Supreme Court pulled the rug out from under all of it. The immediate confusion and scrambling was intense and visible. State attorneys' general offices that had been defending these programs in court suddenly found themselves on the wrong side of a 9-0 Supreme Court ruling and had to figure out how to advise their clients about compliance. But the immediate impact of the ruling itself is only the beginning of this story, because something dramatic happened almost instantly after the Supreme Court issued its decision. Immediately after the 9-0 ruling was announced, lawmakers, legal strategists, and gun rights organizations began pushing aggressively to expand the impact of this decision far beyond the specific confiscation program that was directly at issue in the case. The strategic thinking behind this expansion push is straightforward and powerful. If the Supreme Court has unanimously declared that one form of firearm confiscation without adequate due process is unconstitutional, then the same constitutional principles should logically apply to every other confiscation or seizure mechanism that suffers from similar procedural deficiencies or that relies on the same kind of emergency or administrative justifications the court just rejected. Major Second Amendment advocacy groups, within hours of the ruling, began preparing legal challenges and public campaigns demanding that this precedent be applied broadly across multiple categories of firearms laws. The expansion that's being demanded covers an incredibly wide range of existing policies that have been highly controversial and heavily litigated. Red flag laws, which allow courts to order the temporary removal of firearms from individuals deemed to pose a danger to themselves or others, are immediately in the crosshairs because critics argue these laws often involve ex parte proceedings where the gun owner isn't present and minimal evidence standards that don't provide adequate due process before the confiscation occurs. Emergency seizure powers that law enforcement agencies in various states have been granted, allowing officers to confiscate firearms based on their assessment of imminent danger without a prior judicial hearing, are being challenged as constitutionally indistinguishable from what the Supreme Court just struck down. Administrative confiscation policies where regulatory agencies, rather than courts, make decisions about firearm forfeiture are under attack for lacking the judicial oversight and procedural protections the Supreme Court's ruling suggests are required. Storage-based seizure laws that allow confiscation if firearms aren't stored according to specific government mandates are being questioned on grounds that they punish lawful gun owners for regulatory violations without adequate process. Which brings us to the ultimate question that everyone watching this unfold is asking. What comes next, and what does the future hold for firearms law, government power, and constitutional rights in America? The legal reality is that this 9-0 Supreme Court ruling has set a powerful precedent that courts at every level, from local trial courts all the way up through federal appellate courts, will now have to grapple with and apply. When the highest court in the land speaks unanimously on a constitutional question that carries enormous weight in the legal system, judges who might have been inclined to uphold confiscation programs are now faced with a unanimous Supreme Court precedent telling them those programs are constitutional only if they meet strict standards that many existing laws simply don't satisfy. The battles that are coming are already being prepared in law offices and advocacy organizations across the country. The fight over which of those outcomes prevails will define firearms litigation for years. And there's another dimension to this that can't be ignored. What happens next in the courtrooms, in the legislatures, in the enforcement agencies, and in the public debate over these issues could change American gun rights and government power for an entire generation. The Supreme Court has spoken with one voice, and that voice has declared clear constitutional limits that government cannot transgress. The question now is whether those limits will be expanded to encompass broad categories of existing laws, or whether they'll be confined more narrowly. Whether states will comply with the spirit of this ruling or look for creative workaround. Whether Congress will attempt to legislate in this area in ways that try to satisfy the constitutional standards the court has now articulated. And whether the American people, through their elected representatives and through continued litigation, will push for even more robust protections for Second Amendment rights or will find ways to preserve public safety regulations within whatever constitutional space remains. This is a pivotal moment, a turning point where the trajectory of firearms law in America may be fundamentally altered, and everyone needs to understand that what we're witnessing is just the opening act of a much longer constitutional drama that will play out over the years ahead.